So what next?
Well, what next was, together with the demand letters, that WIPO proceeding and the what Trader Joe said in responding to that domain name proceeding have gone into the allegations of bad faith in the complaint. So the distinction with the ACPA, the cyber squatting claim in federal court, but also with the UDRP, is again, it's a little bit different. It's not trademark infringement necessarily, it's not dilution, it's you've registered this domain name in bad faith. And there are several factors that a Trader Joe's would have to show.
In bad faith, knowing that there was already a Trader Joe's in existence.
Right, or some other evidence of bad faith. And so Trader Joe's had to say, okay, TraderJoeXYZ.com is confusingly similar to Trader Joe's. They did prevail on that factor, but then they also have to prove that Trader Joe, the platform, had no rights or legitimate interest in the domain name Trader Joe XYZ and had registered it in bad faith. They registered it just because they wanted to sell it, or they registered it without any real desire to use it in commerce, or what have you.
So if, let's just say, the owner of Trader Joe XYZ is named Joe, I want to register that name, that's my interest in it. My name's Joe. Any thoughts about that?
You're already an intellectual property lawyer. There you go, because that's exactly what they argued. Trader Joe. One of the founders was the registrant for the domain name, and that's exactly what he argued. He said, no, I have rights and I have a legitimate interest because it's a trading platform, Trader, and I named it after my brother, Joe. So, and that was enough. That was enough. And the UDRP proceeding went in favor, and Trader Joe, the platform, continues to use Trader Joe XYZ. So, but evidence came out on social media and other places later on where folks who worked for Trader Joe platform were saying, no, we came up with this idea because we thought it would be really cool to name, because it's like the supermarket.
If you could somehow make a parody out of the name, would that get you anything as far as legal protection?
Even for a parody, you have to go through the likelihood of confusion factors. Right. I don't think that this would rise to the level of parody, but all of this evidence of they failed to respond to the demand letter, they came up with a false narrative, as they say, in the proceeding before WIPO. All of this goes to show, their bad faith, they're bad actors. Also, the platform, apparently everyone operates using aliases and no one really knows. I mean, the complaints against two companies registered in the British Virgin Islands, but also a bunch of John Does, because it's difficult to know who's really operating this company. So all of that sort of goes to the bad faith allegations. Yeah, and the dilution.
What is dilution? I'm not familiar with that.
Dilution is basically, again, no likelihood of confusion required. So it doesn't really matter that cryptocurrency and supermarket retail services and goods aren't necessarily related in consumers' minds. But we're famous. We're a household name level of fame, so we reach that hurdle. So then we have to show, Trader Joe's has to show, that Trader Joe using Trader Joe for the cryptocurrency platform is impairing the distinctiveness of Trader Joe's famous mark. You can impair distinctiveness in two ways: by blurring, just being another person out there in the marketplace using the name, impairing the distinctiveness of the famous name, or tarnishment. And because of this sort of shady activity that Trader Joe's is alleging that the Trader Joe platform is engaged in, they're saying not only is it dilution by blurring, but it's dilution by tarnishment, because you're eroding the public's good association.
The goodwill associated
with the goodwill
with their name.
Associated with Trader Joe's.
That makes sense.
Yeah. And so finally, that's how Trader Joe's made it to the federal court in California. But, UDRP proceedings, demand letters, these are all good ways to try to resolve a dispute before you bring a complaint. But sometimes, it doesn't work and you have to go there. And then you've built up a nice story, perhaps, of bad faith and willful conduct. Isn't trademark law fun?
That's a great story.